Hi, it's Jerry Roberts, and I am back again with another community conversation. And today we are talking with Judge George Eskin, retired Judge, Superior Court Judge George Eskin, appointed by Governor Gray Davis in 2003, and served until 2013. He had a very distinguished legal career before that in district attorneys, city attorney's office up and down the Central Coast in LA. He is also the spouse of State Senator Hannah Beth Jackson, and most importantly, voice of the Lady Dons, the UCS.
No, Lady Gauchos.
Lady Gauchos. I'm getting my green and gold hair mixed up. The Lady Gauchos basketball team. Thanks for being with us. And,
well, thanks for inviting me, Jerry. Pleasure to be here.
Did you get the senator? Did you get our senator safely delivered to Sacramento? I guess.
No, she's still working from home.
Oh, she is.
Oh, absolutely. And it's an exhausting experience. I've been with her occasionally in Sacramento and watching the parade of people in and out of her office and her going off to committee hearing rooms and whatnot. It's just an amazing pace she keeps, but now it's in our house. And she's occupied the house with her office, and she's on the phone about, I would estimate 12 hours a day. The work that she does is just incredible. And the number of people who are calling her, the numbers of issues that she's addressing and trying to get information out to the public about what's happening on a variety of issues. Of course, right now, the most important being the COVID-19 catastrophe.
Yeah. Well, you know, I'm trying to get her to run for mayor, so we can talk about
the mayor.
Yeah,
that's a losing battle, I think.
All right, let me ask you this. So all of the courts in Santa Barbara County and across California, across much of the nation, have been shut down. The normal operations, there have been
normal operations, yes.
Yeah. So what are the implications of that? Are they going to come back? Are we going to be able to go back to normal, whatever that is? I mean, what are your thoughts on how that, how does that resonate for the criminal justice system?
Well, the implications for the future are that I believe are going to be significant changes, and we're never going to return to the normal that we've experienced over the past 50 years. And I think in your interview with Joyce, you referred to an article that I had shared with you about a re-examination of just what the courts are. They provide a service, a judicial service, a determination and resolution of disputes and a variety of other things. But our traditional concept has been of a building. That's the courthouse. How many of the functions that a court performs can be performed over the internet, can be performed electronically? And how many of them require personal presence in court? I was struck by the Chief Justice who observed that for years and years, attorneys get dressed, get into their cars, drive down to the courthouse, find a place to park, check in with the clerk, stand in line, sit in the audience, wait for their cases to be called, waste an enormous amount of time. And the future may be that they're going to be working from home or from their office and through a television, through a computer screen, electronically. And I personally believe that the only thing that requires the courthouse is jury trials. And that's the only function that a court provides that I have serious questions about in terms of how jury trials are going to be conducted in the future. It is not correct, although I hesitate to start off with a disagreement. It's not correct, as Joyce said, that the critical part of our system is put the brakes on and stopped. What stopped is the traditional business of doing business as usual. The court's still there. Motions are still being heard. Judges are still resolving issues. It's just being conducted in a different way.
Yeah. Well, you've been very active in criminal justice reform issues since your retirement, and certainly Proposition 47, I think, is kind of a landmark in that area. if it is in fact true that courts, become a service rather than a place, what are the implications for that for the unequal administration of justice? Is that something that would benefit a reform, or is it something that would sort of deepen the kind of economic disparities that we see in how people are represented and the kind of justice that they get?
I personally wouldn't anticipate much of a change in terms of providing equal access to the courts or equal justice to the services that the courts present. I think that judges can still consider motions, can still consider, if you're staying on the criminal side, arraignments and whether or not a person is going to remain in custody pending an adjudication of a criminal charge. I think on both the criminal and the civil side, disputes can be resolved. It's just not going to be the way we've always done it, by going to the courthouse. I don't think I don't think that the issue that you raise is one that we need to be terribly concerned about. We do have right now an issue of balancing the competing interests of due process versus public health. And I think that public health is going to prevail, and we have to figure out how in the world we're going to provide due process both on the criminal side as well as the civil side, so that people have notice of the dispute, notice of charges, and an opportunity to be heard. What's going to be difficult, I think, and I don't have an answer, is how witnesses are going to be examined and cross-examined, and how much of that is going to happen in the same room, or how much of it is going to be handled remotely and electronically.
Well, I wonder, from your experience, sitting on trials and so on, I mean, is there kind of a factor of people being close to each other physically, someone on cross-examination, for example? My own experience, I know, having been cross-examined, it can be an intimidating or threatening thing. What would be different in terms of the sort of, I guess, performative aspects or actual physical aspects of the trial that would be online rather than in person?
Well, it's going to be very different from the way we've always done it. And we're accustomed to watching trials on television and in motion pictures. And sometimes attorneys on cross-examination get overbearing and intimidating, and judges have to tell them to step back and give the witness space. I just think that the whole practice of law and the way in which litigation is conducted will be changed tremendously. And attorneys are going to have to learn new techniques, new approaches to obtaining information from witnesses and conducting cross and direct examination.
Going back to the last ice age, when I worked in Sacramento, funding for the courts has always been an issue. Workload has always been an issue, and I know that's only gotten worse over the years and over the decades. Do you think that this kind of change would lessen that? How would it affect workload issues? How would it affect funding for courts, do you think?
Well, I'm really not an authority on the funding issues, Jerry. I really don't feel equipped to answer that. I just think everything is going to change. And and the changes are multifaceted and dynamic. And I'm not a futurist, so it's hard to speculate about how funding is going to be impacted by the fact that we won't, in my opinion, need as much concentration of funds at the courthouse, and it's going to be more staffing and processing papers and doing things online. When I say processing papers, I mean electronically.
Right. Yeah, I think it's just one more thing. I think people who are talking about, let's open up the economy and stuff, the notion that when we're going to go back to the way things were 3 months ago, I think is just wrong at so many.
No, I agree. We're not going to go back to the way things were, but we're going to be examining and exploring things that have been proposed to reduce court workload much more seriously. For example, one thing that has been proposed over the recent years has been, why is traffic court in the courthouse? And should traffic violations be the subject of administrative proceedings, perhaps through the Department of Motor Vehicles? Should we have court trials for traffic cases where most people who get a citation go to court with the hope that the arresting officer, the citing officer, won't show up? If the officer doesn't show up, then the case is dismissed. If the officer shows up, people frequently plead guilty. And I think that kind of practice is going to disappear. How it's going to disappear, I'm not exactly sure, but one potential solution is you get a traffic citation and you're invited to present a written declaration of your version of what occurred, and a judge or administrative officer will read the declarations of the officer and of the person who gets the citation and make the decision on that basis. Trial by declaration, I think, is going to replace going to the courthouse and having law enforcement officers, highway patrol officers, deputy sheriffs sitting around waiting for their cases to be called. So in terms of funding, we won't have to spend as much money, I think, having law enforcement officers sitting around the courthouse waiting for their cases to be called. They'll be able to do it by declaration or by video. So that's just one small thing. I think everything that goes on in a courthouse now is going to be re-examined. And one thing that's come out of one of the first things that came out of the Judicial Council's orders was this business about bail. And
what's that, emergency rule 4, I think?
Right. And there's been
what is that? Can you explain what that is? What is the, go ahead.
Well, looking forward, I think that the legal community, the justice community, is going to be looking at, why are people being confined in jail pending an adjudication of their charges? One reason is the public safety risk. But when we're looking at what the Supreme Court Chief Justice declared were misdemeanors and nonviolent offenses, we have to ask ourselves, is a person being detained in custody because they can't afford to buy their way out? Or is it because they represent some kind of public safety risk? And I think that is the consideration that we're going to have going forward. Of course, we have this veto referendum in November that will decide whether Senate Bill 10 is going to stay in place and go into effect in January. Well, that's a whole different issue.
Yeah, let me, I just kicked over my water. Let me back up, because there was a lot of stuff there to unpack. So the first thing we're talking about is this emergency order that was put in place because of the coronavirus,
right,
to have zero bail for misdemeanors and certain nonviolent felonies,
right,
as I understand it. That's a separate issue than from Senate Bill 10. And what is Senate Bill 10, SB 10?
Well, Senate Bill 10 replaces cash bail. There will be no cash bail if Senate Bill 10 prevails. Instead, we will have a system in our county of the probation department doing pretrial investigations and assessments of the risk associated with the release or non-release of a person who's been arrested for any offense. But it's similar to the standard that the interim rule has imposed, and that is there's going to be almost a presumption that people will be released on misdemeanors and nonviolent felonies, subject to supervision, subject to conditions of release, which is also available now under the interim order regarding zero bail.
And can you talk about the sort of the policy theory behind SB 10? In other words, what are we trying to accomplish? What wrong are we trying to right? Why was it passed? What do its supporters say?
Well, the policy considerations basically have to do with the fact that poor people stay in jail and rich people get out. And they may be charged with the same offense. That's one of the policy considerations, and that's certainly a denial of due process. Another policy consideration has to do with the elimination of bail schedules. which I think is very important. That's something that SB 10 does. There will be no more bail schedule, and they're very arbitrary. And not only are they arbitrary, but they differentiate between county and county. You can have a bail schedule of $250,000 for an offense in Kern County, and the same offense may have a bail schedule of $50,000 in Santa Barbara County. The numbers that are associated with the bail schedule have absolutely nothing to do with the defendant's circumstances or the particular offense. It's just an arbitrary number assigned to an offense. And
where does that come from? Who sets that?
every county in the state is required, every superior court in the 58 counties of the state is required to adopt a bail schedule in March of the year. And the bail schedules are, I mean, they're huge. The numbers of offenses that are listed and the numbers that are attached to them do not have any particular rhyme or reason. The truth of the matter is, Jerry, that bail is there to keep people in when bail originally was to get people out. And so judges are being asked to to impose an amount of bail that is not likely to be satisfied by the defendant and keep the defendant in custody. And that's completely contrary to what bail was supposed to be all about when it was created.
And now is Senate Bill 10 in effect, and the proposition is trying to undo it, or is it not taken?
Yes. The bail industry has managed to get sufficient signatures to put on the November 3rd ballot a veto referendum. And the people will be asked, voters will be asked to veto Senate Bill 10. And if that referendum passes, then Senate Bill 10 is off the books and we'll be back at square one.
Can you talk a little bit about the whole bail situation in kind of what's happening nationally? I mean, I try to follow a lot of issues, and I haven't kept up with this, and I should have. Is California really leading the way on this issue? Is there a national movement to be doing this?
We're not leading the way, but we're trying to play catch up with some states that have been leading the way. States that have led the way are New Jersey, New York, Kentucky, Maryland, and basically what California has done in SB 10 and other recommendations is to embrace the Federal Bail Reform Act of 2 or 3 decades ago. The system that SB 10 would put in effect is very much like the District of Columbia's approach to bail. And it's basically a presumption that people will be released unless the prosecution can show that the release of this person represents a threat to public safety or a risk that the person will not appear in court.
I was in Sacramento when a lot of the 3 strikes legislation, the very punitive incarceration things were passed and signed into law by Governor Brown and then later by Governor Duke Nugent. Is this is what we're seeing broadly a reaction to that era? Is this people are understanding that it didn't work or that there's an underlying racism to it?
I don't think that racism drives it. What I do think is what drove the efforts in the 80s and 90s was a belief that if we lock people up who commit crimes and throw away the key, we'll all be safer. And the consequence of that was to increase the population of our prisons, cause us to build more prisons. And the prison population was up in the hundreds of thousands. And now it's been reduced significantly because we realized that while we were locking people up, we weren't doing anything or doing very little ineffective in reducing recidivism, reducing the repeat offenders once they're released. And I think the important point for everyone to recognize, Jerry, is that everyone who's in custody, other than those who are in custody on capital charges or life without possibility of parole, everybody else is going to be released from custody today or tomorrow or next week or next month or next year, but they're going to be released. And that's true of the people who are now being released after 21 days of a 40-day sentence or 15 days of a 45-day sentence. The question that we have to ask ourselves is what conduct merits incarceration, number one, and how long does the period of incarceration need to be? What are we accomplishing during that period of incarceration? What are the purposes of having incarceration as a consequence of an antisocial or criminal act? One purpose of incarceration is deterrence, the notion that people won't commit crimes if they know they're going to go to jail. Another purpose of incarceration is punishment. You're going to be punished for having done this crime. And during the period of time that people are incarcerated, something positive should occur so that when they re-enter society, when they walk out of the jail, when they walk out of the prison, they're in a different place than they were when they committed the crime that caused them to be prosecuted and convicted and incarcerated in the first place. So I think the focus during the last 10 or 15 years, starting around 2011, the focus has been on the underlying causes of the criminal conduct. Let's address those. It's not just a question of coddling criminals or being soft on crime. It's a question of getting to the root causes of the crime, and can we deal with those in the hope that we're going to affect people's conduct in the future. Locking them up and doing nothing does very little other than making them more sophisticated criminals.
And it's expensive.
Oh, absolutely.
For society to be doing that.
Absolutely.
So do you see a movement in California towards more of a rehabilitation model that it seems to underlie the assumption underlying your comment there?
Oh, Jerry, I don't think there's any question about that. I don't use the word rehabilitation, even though it was popular back in the 60s and 70s.
I'm dating myself.
No, I just don't use that word. Everybody uses that word. I don't. I use the word reentry. And I think reentry captures the reality that people are going to be released from custody today and tomorrow. And if are they in a better position to re-enter society successfully or return to the conduct in which they engaged that caused them to be incarcerated in the first place? What are we doing to address the underlying causes of their criminal conduct? That's where the focus needs to be.
And that would be what? Addiction, alcoholism, mental illness, foster childhood.
Why do we incarcerate people who are in public intoxicated? Why do that person should be locked up and thrown in jail because they're drunk, or that person is addicted to drugs? That's been our traditional approach to offensive behavior. Throw them in jail. There ought to be a law. And now I think, we have a wonderful probation officer chief probation officer in Tanya Heitman. And Tanya Heitman is very sensitive about public safety. Tanya Heitman is very sensitive about protecting the public against bad behavior. But Tanya Heitman also has a keen sensitivity to getting to whether the issue is mental illness, whether the issue is drug addiction, whether the issue is alcoholism, whatever. What the issue may be poverty, the issue may be a lack of education and training skills to get people into the workforce because they haven't received the kinds of basic education that will prepare them to survive in a very complex and changing and complicated and competitive society.
So I asked Joyce Dudley this question yesterday. Let me ask you. So during the pandemic, we have seen the county jail population reduced from about 900 to about 400, so as not to put prisoners at risk of the coronavirus.
Reduce the risk.
Reduce the risk, yeah. So what does that tell you? Did those people need to be in jail in the first place, do you think?
Well, incarceration serves a purpose. But the question is, how long should the period of incarceration be? And I think much more importantly, is what is being done with those who are convicted of criminal offenses to try to reduce the likelihood that they're going to reoffend. And that's where the probation department in our county comes into play. The probation department will supervise people, and that's what can be done now before conviction and after conviction. People can get into programs that will address their needs, the needs that they responded to by committing a criminal offense, before a person is convicted and continuing after they're convicted.
All right, we got just a couple minutes. I want to ask you two sort of national questions. One, we saw the United States Supreme Court televise a hearing for the first time ever.
Yes,
That was historic,
and long overdue.
and Judge Thomas actually asked questions there.
He did. I didn't know that.
Yeah,
Surprise.
no wonder. So, I mean, do you think again that's going to be the new normal going forward? That
Oh, absolutely. Why shouldn't the Supreme Court proceedings be televised? Why shouldn't the public be able to see the way in which the Supreme Court justices consider issues, the thoughtful way they ask questions, the way they're presented? Absolutely. I hope that they are going to continue to, and expect that they will continue to televise their hearings in the future.
all right? And the last thing is, obviously we have a very divided country, polarized country, and a big election coming up. But no matter who wins, I mean, how much do you think, or how extensive do you think President Trump's appointment of judges at various levels of the federal court system will affect us, for a decade or 2 decades going forward? How important do you think that is?
Well, I think it's profoundly important. But the only judges that I know about who have been those who have been the subject of controversy, those who have been deemed to be unqualified by the American Bar Association's judicial evaluation process, those that have identified themselves as being very partisan. And I think it's a very troubling proposition, and it concerns me greatly.
All right. All right, Judge George Eskin, thank you so much for visiting with us. And
Thank you, Barry.
give our best to the state senator, and go Gauchos.
Go Gauchos. Oh, go Dons too, but go Gauchos.
All right. Talk to you
Thank
soon.
you. Bye-bye.